Good morning, everybody, and welcome to the 10th District Court of Appeal with the 1st District Court of Appeals sitting in place of the 10th District today as a visiting judge panel. We are continued in progress from our hearing earlier this week.
Plug in the headset, or do you have a headset?
And I am going to ask everybody to put themselves on mute for the moment. And also throughout the hearing, I will request that you keep yourselves muted unless you are talking. That will assist us in this hearing this morning. Before we begin, I wanted to go over some additional ground rules because we as a panel had a chance to think about the timing this morning. And in the interest of time and in the interest of fairness to all the parties, here is what we intend to happen this morning. The first issue that the panel will need to ultimately decide is whether there was frivolous conduct in this case. And as you know from our last hearing, the issue we will be looking at is whether the filing of the notice of appeal was frivolous conduct. And so in that regard, we are going to limit the testimony with respect to the issue of whether the conduct was frivolous to testimony about whether the filing of the notice of appeal was frivolous and not go beyond that. And I think we covered that at the last hearing. If the panel ultimately decides that conduct was frivolous under Ohio law, then the next issue the panel will need to decide is what sanctions, if any, and what attorney fees, if any, to award as a result of that conduct. And as you know, we all asked the parties to address the issue of the recoverability of fees after the date of the dismissal of the notice of appeal. And because of our time constraints this morning, I am going to ask both sides to limit their examinations of the fee issue to the time up until the notice of appeal was dismissed by the 10th District Court of Appeals, which I believe was June 26, 2020. So in other words, because of our time limitations, the fee issue that I want everybody to address this morning is fees up until that time. If we decide that we need to go further and have a further hearing on the other fees, we will schedule it for a later hearing. But because we only have 2 hours total allotted today, we wanted to make sure that we did this in an orderly fashion and at least got to those two issues. And as I said, if a further hearing is necessary, then we will reconvene at that time. Let me ask the panel members, is there anything either of the panel members would like to add at this point? Let me start. Ms. Rosen, were those instructions and guidance clear to you this morning?
Yes, Your Honor.
All right. And Mr. Woodford, did you understand the time limits that I just set out today? I think you'll need to unmute yourself.
Yes, Your Honor. Good morning. I did understand what you said.
All right. Thank you. Let's begin where we left off, and that is, and I see Mr. Mackey is still connecting to audio. So I think, Mr. Mackey, can you give a thumbs up if you can hear me?
Does Mr. Woodford know that we don't have any video of him?
Okay.
I have audio now, but I have to call through my phone. Something won't allow me to participate. So can you guys hear me?
Yes, we can hear you. All right.
Thank you.
Mr. Mackey, were you able to hear my instructions for today and what we're limiting the testimony to? Very briefly, we're limiting the testimony today to whether or not the conduct of filing the notice of appeal constitutes frivolous conduct. And because of time limitations and fairness to both sides, we're going to focus the fee issues today up until the time that the notice of appeal was dismissed, which was on June 26th, 2020. And if we need further hearing, we will reset this for hearing at a later date. And Mr. Woodford, okay. I believe that you were in the middle of examining Mr. Mackey on, and is it Mack or Mackey? I may have been saying it wrong.
Mackey.
All right.
Mackey.
Thank you. You were, I think, examining him on the fee issues, Exhibit G. So you may proceed at this time.
Yeah, excuse me 1 second, Your Honor. I'd like to say something here that's a little troubling to me. I see a gentleman in the background there. It looks like Mr. Frank Mackey, former attorney. I'm very concerned that he's coaching his son, or in some way, he's a non-party to this action. And I really am not comfortable with him being around. No difference if this thing were being in a courtroom, he would not be able to be there. So Frank Mackey, who is a 40-year attorney, I do believe is coaching his son, very much involved, and I'm very uncomfortable with him being in the room with Mr. Alex Mackey as we're proceeding with this hearing today.
All right, let me just address something briefly. This is a public hearing, so Mr. Mackey, and we're streaming it on YouTube. The senior Mr. Mackey would be able to watch it and participate like any other member of the public. However, what he cannot do is talk to Mr. Mackey during the course of the examination, to pass him notes, to make signals to him. And so, Mr. Alex Mackey, I'm going to ask you, are you alone in the room that you're sitting in?
My dad's sitting in the chair next to me over here. Would you like
All right.
him in the other room?
In an abundance of caution, I am going to ask that he move to a different room and that he participate only as any other member of the public would.
That's fine.
All right. And as soon as you're ready, Mr. Woodford, will let you begin resume the cross-examination.
Okay, now another question here. You had stated that I have 15 minutes with Mr. Alex Mackey. If I chose to dedicate 30 minutes towards him and then subtract 15 minutes from my examination, can I do that?
Yes.
Okay. So I'm going to watch the clock. I just got so much information here. It's not humanly possible to get through it within 15 minutes because, again, what's at risk here for me is attorney fees that will exceed $10,000 before this thing is over.
Not today, Mr. Woodford. The only thing.
I'm leaving that alone today. Thank you.
Yeah, the only thing today is
up to the $1,000 number that they had going into June 26th. I got it.
Correct.
Thank you.
All right, and you may begin.
Thank you. Good morning, Mr. Mackey. Would like to go ahead and finish up here with you as best we can. And again, as you heard the courts, we want to limit most of these questions to yes and no. We don't want to hear about you being, trying to manage a 167 unit building. We just want direct, definitive answers. You had stated on the record before that this was your first time, you've never been involved with any court proceeding, and this was your first time being involved with something like this. Is this true or not?
With something like this for attorney's fees, it most definitely is. But I think like any other person, who's lived, you've gotten a traffic ticket here or there.
Okay, very good. That's fine. That's enough. Let's talk about, you brought up traffic tickets. Let's talk about traffic tickets that you had back in 2003. Let's look here. I actually have those with me. You've had traffic tickets 2003, case 202357, and you have 216-121-220 speed. The other one was a control device, 216. You failed to stop at a stop sign, and then you were in an accident in 206 in which you pled guilty. Question for you. In any of those situations, had you been drinking alcohol and or smoking marijuana at the time of any of those incidents?
Your Honor, I'm going to object. Mr. Mackey, don't answer. As the question is outside the scope that the court has set for this hearing.
Sustained.
Okay. Mr. Mackey, question here. Can you point to the damages that you incurred as a result of what you're calling frivolous conduct leading to your decision to ultimately file for a motion for attorney fees? Can you point to any and all damages that you incurred as a result of me filing the appeal on this decision?
Yes.
Provide those damages to the court, please.
Mental anguish, you know, of one of several suits that you have caused and filed and withdrawn, the mental anguish. Other cases, I mean, we could list all those cases out that you have pulled or still have active or dismissed. Your overall conduct, which led to a protection order, and then after the point the decision was rendered in the protection order, going back and appealing the protection order without appealing the other protection order, which I think in court the other day you said you might have made a mistake in doing so because you weren't represented by counsel. I've always paid my attorney bills. I think my ledger's current with them. This is just one thing that I didn't want to be involved in with you, and you brought on.
So talk about the mental anguish. Have you seen a psychiatrist, a psychologist, or is this just something you have a ledger, any kind of evidence that you're experiencing mental anguish relative to this dropping, relative to this appeal?
Through the whole process, not only this appeal, which is just so small in the big scheme of what you've been up to, everything that leads up to it, it's just another, oh shit, I have to hire an attorney.
So how does this bring on mental anguish?
The minute you appealed, because it's something that I wake up in the morning not wanting to think about. You know, it's like, hey, you get news that you have to have a tooth extraction or a root canal, and that was at 9 o'clock. At 8 o'clock, you walked into the office. You had no idea that was coming. You know, that causes you mental anguish. Anything that is outside of my lane that comes into the lane that isn't caused by me is mental anguish. You know, the human body is always at the stage of adjustment. We constantly adjust.
Do you have any written documents? Have you hired a psychologist, or have you seen a mental health expert regarding your mental anguish?
I've seen a mental.
I'd like to interrupt here for a minute. I know Ms. Rosen has not objected, but the court has set limits, and so I'd like to address that. Ms. Rosen, are you seeking any damages for mental anguish in connection with this request?
No, Your Honor, we are not.
All right. Mr. Woodford, the reason I stopped is my understanding was the only thing they're seeking is legal fees, not any other damages.
Okay.
I'm going to ask you to confine your
Thank you, Your Honor. Mr. Mackey, again, what frivolous conduct up to the relative to me filing that appeal? What about that was frivolous?
It lacked the transcript. It lacked any written objections to the magistrate's decision, and it's already discussed. The appeal of one protection order gave you no leverage without appealing the other one. And I think it was admitted.
And with that in mind, okay, how do you justify me paying your attorney fees at that point?
Because I didn't file the appeal.
You did, okay. And so in your mind, what you're telling me is because I didn't have a transcript in there, this was frivolous conduct in your mind?
Yes, because the judge.
Yes or no? Yes or no?
Yes. Yes.
If I would have made a mistake, would that be considered frivolous conduct?
I don't know the answer because you're
Your
asking.
Honor, I'm going to object. Your Honor, I'm going to object. I think that calls for a legal conclusion.
No, it doesn't. No, it doesn't. It's a simple
Your Honor,
question.
Your Honor, Your Honor, I think you're muted.
Sorry, I sustained the objection.
Okay. So, Mr. Mackey, here again, in order to prove frivolous conduct and get any of your attorney fees paid, you must prove that. This is what you've stated. What evidence do you have that my conduct was frivolous?
From the advice of my attorney, when they read the initial appeal and were perplexed by the actions you took of appealing just my appeal. I sought professional legal advice the minute I was served with the appeal notice. And it was very similar to when you filed the ultimate dismissal, was very similar to the 2018 lawsuit which you filed against myself, my LLC, and several other people that you ultimately one day dismissed. From day one of that, I hired an attorney. I didn't make any conclusions on my own. I relied on an expert.
So you relied on an expert. Let me talk about your expert. Look at Exhibit 12. Do you have a copy of that?
I think we confirmed yesterday that your exhibit seemed to end at 10 or 11.
I filed these yesterday. You'll see in Exhibit 12 that was delivered to your attorney at about 1 o'clock.
I've not had time to review the 300
okay, well,
pages.
Let me share this with you real quickly.
Today.
Your attorney obtained a judgment against a client in case 216 CVF 024260. She obtained a judgment, and then the defendant went out and retained an attorney named Stephen Lennon, who is one of my attorneys on some of these matters I've been involved with. And your attorney backed up, and the attorney that was representing Mr. Hondas, the defendant, he vacated her judgment. And so the client that she was representing, if you read the docket there, and I know you haven't.
I'm looking at it now, but I'm looking at it, Carl, but I've got concern because I see the attorney's name is Walter McNamara and my attorney is Kristen Rosen.
Well, I'm just saying within the same, she's the, that's her firm, but McNamara's a attorney within her office. So my point is they received a judgment. This is the point. Received a judgment in this case. An attorney showed up because early on, Mr. Hondas was pro se, or they got a default judgment against him. The bottom line is when an attorney came on the scene, they backed up and that judgment was vacated. Okay? So I don't want to hear about how great your attorney is. I'm asking you the question. It's a simple
What kind of lawsuit? What kind of lawsuit?
I'm talking, Mr. Mackey. You can't talk over me. Just answer the question. I'm asking you, when that fee was $1,000, what evidence do you have that my conduct was frivolous? What do you have in writing to substantiate your frivolous claim? Where are your exhibits?
My attorney's ledger. From the day I had to hire an attorney, from the day I hired an attorney, I think you'll see on that ledger, there was a conference initially regarding it.
Okay, but that's not sorry, that's not evidence, sir, as to frivolous conduct. I'm asking you a simple question. You're wasting my time, and the courts see this. What evidence do you have in writing that shows I was frivolous in filing that appeal?
I don't have evidence. I do have conversation.
That's fine. You have no. So your answer is
we have been over and over this same issue many times, and people are talking over each other. Mr. Woodford, I think you've asked that question, and Mr. Mackey has answered. I'm going to ask you to move on to another question, please.
Okay, thank you. So for the record, he's made it clear he has no evidence that
I do.
My conduct was frivolous, is what he just stated. Okay?
Mr. Woodford, this is not the time for argument. The court will take all the evidence under advisement.
You had exhibits.
Mr. Woodford, let me finish, please.
Sorry.
What will not happen today is that we focus on issues that are not before the court. And I'm going to ask you to stick to those, and what is in the record will be considered by this court.
Okay. Very good. So what's in the record as of now, Mr. Mackey, here's a question for you. Why did you withdraw your exhibits that were going to be used as evidence? Mr. Mackey's not with us.
At the advice of the attorney. That was my attorney's decision. She said we were getting off scope of where we needed to be, which was exactly what the judges just said regarding attorney's fees on the appeal of the protection order that you ultimately withdrew after filing the appeal.
Okay, so here's a question for you. The $1,000 that we're talking about was up until the point of about June 25th. That's what your attorney fees were at that point.
Yeah.
My question to you is very simple. Very simple today. Do you feel like I have harassed you? Is this some form of harassment for me to file the appeal?
Yes, I'd ask when you filed the appeal.
So why? Okay, did you read? Okay, I have exhibit here, and I'm hoping that you have it. Did you get a copy of the exhibit where I was on the front page of the Columbus Dispatch, black in Bexley? Did you get a copy of that? Did you see that?
I just glanced through that, and the Dispatch would be the same. Publication.
I don't want any explanation. I just asked a question. Did you receive a copy of Exhibit 19?
Is this part of the 300 pages that were sent out later?
Mr. Mack, it's this document right here, Exhibit 19.
Is it in the attachments that were the original attachment with your appeal, or what you sent out?
No, I just served your attorney with these documents yesterday.
Okay.
Do you have Exhibit 19?
Does that say foreclosed and fleeced?
No, it's you see what it says right here. What Black Lives in Bexley, Exhibit 19, Mr. Mackey. Here again, you're wasting the time. It says what it's like to live in Bexley while black. One family story. Front page Columbus Dispatch.
Yep, I finally got to it in the third attachment.
Okay. Have you read this article before?
Your Honor, I'm going to object unless Mr. Woodford can explain how this relates to our limited scope.
I'm going to, if you will let me finish, Ms. Rosen.
Sustained.
Okay. Mr. Mackey, this article featured me and my family on the front page of the Columbus Dispatch. Okay. I'm a man who has 5 children, and I've lost my wife to cancer 4 years ago at the young age of 53. The question is, with 5 kids, several at Ohio State University with 4.0 averages or above, 1 daughter who just graduated from UC Business College, is a Price Waterhouse auditor and a CPA. 1% of African Americans in this country have that designation. The point is, do you think I have the time to waste to harass you? Yes or no?
Yes.
And explain why.
There's a barrage of YouTube videos, Craigslist ads, where my name, accusations.
We're talking about this appeal only, Mr. Mackey. It's limited to this appeal filing only.
Which was an appeal of a CPO protection order that was granted for 5 years because your actions and the reactions that took place.
Mr. Mackey, it's limited to this appeal filing and dismissal.
And it's
That's all I want to limit this to.
It's an appeal of a civil protection order, which all that's the compounding evidence and the procurement of cause to the civil protection order.
Did I have the right to file that appeal? Yes or no?
Your Honor, objection, that's a legal question.
I'm going to sustain it on the asked and answered basis. I think he asked that and Mr. Mackey answered it yesterday, so sustain.
All right.
And Mr. Mackey, you have used your first 15 minutes. You are free to keep going, but I'm going to encourage you again, limit it to those very narrow issues.
Mr. Mackey or Mr. Woodford? Ms.
I'm
Myers,
sorry,
you're-
Mr. Woodford. Mr. Woodford, you may continue cross-examination or you may
Okay.
wait, either way, but your time will be used up in other areas.
Okay, well, let's go ahead and take a break from that. If I use up my 15 on him, then I have other questions, but I want to move forward with that
All right.
understanding.
All right, thank you. Any redirect of Mr. Mackey, Ms. Rosen?
No, Your Honor.
All right, then you may call your next witness.
Your Honor, I call myself.
All right, you may begin. Please
You
raise
want-
your right hand. Do you solemnly swear that the testimony you're about to give this court will be the truth and nothing but the truth, either under penalty of perjury or so help you God?
I do.
You may begin.
Thank you, Your Honor. Before you, you have Exhibit G, which is a client ledger for Alex Mackey. The case number is listed at the top of the ledger, 20 AP 40. I would direct the court to consider, pursuant to the limited scope today, the time entries from February 7th, 2020 through June 26, 2020. There is a listing of myself, which is KER, the number of hours times the hourly rate, and then a description of the work performed. And then to the right, there's a column of fees, and then billing and trust activity, which is to the right, further right of that in columnar form. Respectfully, we would submit that the hourly rate, well, let me back up a little bit. I'm an attorney that's been licensed in the state of Ohio for a little more than 21 years. The hourly rates for members of my firm range from $95 an hour for paralegal work to $195 an hour to $275 an hour. The hourly rate that the firm charges for work in Franklin County, Ohio, is consistent with the hourly rate charged by attorneys in the Central Ohio community with similar experience, ability, and reputation. The time that was charged from February 7th through June 26th was fair and necessary to familiarize myself with the case and take appropriate measures in the representation of Mr. Mackey. The amount charged was reasonable considering the difficulty of the legal matters at issue and the time and labor required and the novelty of the questions involved. And the time and rate charged is reasonable based on the skill required to perform the services properly, and the amount involved and the results obtained. I would note that on June 26th, the appellant did move and the court accepted and dismissed the appeal. The firm has had a professional relationship with the appellee since 2018. So there is a somewhat lengthy professional relationship between the appellee and the law firm. I would submit that the experience, reputation, and ability of myself as a member of the firm, and I would note that with respect to the time entries in question, I was the only lawyer that worked on the matter, that the work and the hourly rate that was billed is reasonable within the factors that the court would consider pursuant to the rules of professional conduct, Rule 1.5. With that, I have nothing further to offer on direct.
All right, thank you. Mr. Woodford, you will have 30 minutes cross-examination if you need it, and if not, time can be used elsewhere.
Thank you. Ms. Rosin, I'd like you to tell me, you said you've been practicing law for how long?
21 years.
For you to have brought your attorney fees were about $1,000 at the time of the dismissal of the appeal. Is that correct?
That sounds about right.
And those, did you ever file a motion to obtain those fees only?
No.
And why did you not do that?
Well, we filed a motion for frivolous conduct and the award of fees. We are seeking, I didn't limit in our motion or request that we only obtain the fees from February through June. Rather, we requested all the fees associated with the frivolous conduct. So we are seeking all of the fees incurred by the appellee in the matter.
So again, at this point, would you mind explaining how $1,000 fee schedule for work performed until that point, up until to date, has blossomed into nearly $10,000, chasing a $1,000 attorney fee? You're billing after billing after billing to chase a $1,000 piece of money. Your firm is now up to nearly $10,000. Now, if my recollection serves me, many years ago, that would be considered illegal and a crime. If you're treating this like an investment, what have you done? What has changed so that $1,000 for work that was done up until the dismissal by this court, how in the world do you justify another, probably at the rate of your billing, another $10,000 chasing a $1,000 fee? Would you please explain that to me and the court?
Sure. Mr. Mackey, the statute that relates to
I'm Woodford. I'm Mr.
I'm sorry,
Woodford,
forgive
not
me. Forgive me. Mr. Woodford, the statute that permits the appellee to file for frivolous conduct has as a remedy the award of attorney's fees. We have provided the court with case law that the court may consider that allows the court to include in its award the fees incurred with bringing the motion. And so all I can say in answer to your question, Mr. Woodford, is Exhibit G does reflect the time spent and the rate billed for all matters pertaining to not only up until the dismissal of the appeal, but also incurred related to the bringing of the motion and satisfying the requirements set forth in the statute.
And okay, so now that's interesting you say that. What statutes are you relying on that allows you the award of attorney fees?
It's revised code 2323.51.
Now,
and
within that statute,
Mr. Mackey, I'm sorry, Mr. Woodford, if I might also add, the basis of our motion was not only the statute, but also Appellate Rule 23. Just want to give you a complete answer.
Okay, I got that. Now, the fees in question, though, here's the pitch. While this seems to be illegal and unlawful to me, $1,000 is the number. Those were the attorney fees that were incurred for doing whatever work related to the appeal and the dismissal. Was there a brief file? Did you have to file a brief for the appeal?
For the
yes
appeal?
Or no?
No.
So with that in mind, and you're calling my conduct frivolous, okay? If I would have filed a brief and dropped it, how much more attorney fees would your client have incurred Had I filed a brief, had you filed a brief, do all your preparation, would that be another $5,000 perhaps?
Mr. Woodford, that would be speculation, and I cannot guess as to what the fees would have been had you taken certain steps. I have absolutely no idea.
Okay, but the fact is I didn't file a brief. Okay, why don't you point in the record what conduct is frivolous by me filing the appeal, one, by me dismissing the appeal, two.
Mr. Woodford, I will direct you to our motion for attorney's fees, which outlines the frivolous conduct. It's based on not only the statute, but the provisions of Appellate Rule 23. And we also cite to Civil Rule 65 that requires you to obtain a transcript and file objections prior to filing an appeal. In the brief, we also cite to case law that requires a court of appeal to dismiss if those things are not filed. And we make the argument in our brief that no reasonable attorney would have filed this appeal because there is no mechanism by which you could have prevailed. That's the first argument. The second argument is that we believe that your filing of the appeal against Mr. Mackey alone was for the purpose of harassing or maliciously injuring Mr. Mackey because you selectively appealed only his CPO and not an identical CPO against his father. So in other words, even if you had prevailed in reversing the CPO against the appellee, Mr. Mackey, you still would have been subject to the identical restrictions. So you really would have accomplished nothing. So those are laid out in our brief. And I'm happy to restate them for you here today.
You have, and as you laid those out, you had exhibits attached here the other day that you withdrew. Would you mind explaining to the courts why you withdrew those exhibits that you wanted to use as evidence against me?
The rationale was to narrow the scope for the court's consideration to this appeal only and for purposes of expediting this hearing.
But the way you laid it out was as if those exhibits were examples and illustrations of my frivolous conduct. Is that correct?
Again, Mr. Woodford, those exhibits are no longer part of this proceeding. So although it's awkward, Your Honor, I would object to the extent that questions about those exhibits aren't proper given our narrowed scope at this point.
Well, I'm going to give him some leeway to ask you factual questions, but I'm going to sustain that objection because it calls for work product and a legal conclusion. But Mr. Woodford, you may ask her actual questions.
Okay. So again, I'm going back to the frivolous. Okay, so if in fact you prevailed in your mind and my conduct was considered frivolous for filing an appeal,
I think Mr. Woodford is frozen. Mr. Woodford, if you can hear us, your screen is frozen and we cannot hear you. Mr. Woodford, can you hear us? If you can hear us, Mr. Woodford, I'm going to ask Mr. Souter to put everybody back in a waiting room. I'm going to ask you to log off, log back on, and we will reconvene as soon as everybody is back. Mr. Souter, if you can place everybody in the waiting room. Mr.